Welcome to Much Obliged, and I am K Priya, a lawyer, a mediator, author, and arbitrator. This is for all UPSC and judicial service aspirants, law students, and all those who are interested in the Indian legal system. This is the first in the series on PIL, paper 2 of the law syllabus for the UPSC exam, under the heading Contemporary Legal Developments, and we will be tackling other topics in UPSC Law papers 1 and 2 syllabus as well. In this video, we will cover the concept of PIL and its basis. Please like this video and subscribe to our channel. PIL, taking the bull by the horns. In this episode, we will be taking a good hard look at what PIL is. We will cut away all the extraneous hype and go to the root. Take the beast PIL by its horns and give it a good look. So let us begin. If you see the picture, India's PIL plays an important part in the report of the Grantham Research Institute of the LSE. It has become so much a part of our legal system that it is recognized worldwide as a particularly Indian legal tool. The next news item is a little disappointing. The judges feel that PIL is being used inappropriately. How did we get from creating a unique tool to making it so much a part of our system that it is overused and misused and taken for granted? We shall be seeing it next. Let me tell you a story. Don't get worried. This is not some long and rambling bedtime story, but it is actually a slice of our history. And to go there, we'll need to take a long step back down to 1975. Imagine the state of India in 1975. There was overcrowded and scanty public transport. Almost the majority of the population was poorly educated or uneducated, so most people were unaware of their rights. There were very few courts, and this, coupled with high legal fees and rampant poverty, meant that few people could access and approach the courts for even relief from the worst human rights abuses. There was just no access to justice for the poor. Then came the emergency, and it made things much worse. This was 1975 to 1977. Rights and remedies were suspended. No one had access to courts for relief. Streets used to be dark and deserted by 7 p.m. and fear stalked the streets. News was controlled and there were no private news channels. You never knew if it was your house that the police would knock on at night. There were whispers of atrocities by government officials and private people, and no one could do anything. All this changed with the lifting of the emergency. The freedom after the emergency lifted was just so widespread. Papers began giving real news. They shone a torch into all the dark corners, and all the skeletons came tumbling out of atrocities, negligence, repression, brutal abuse, arbitrary acts by government officials, private parties, and it all just came pouring up. It inspired a number of people, activists, judges, lawyers, journalists, and doctors to new heights of activism, including legal activism. So the post-emergency period saw the Supreme Court rise to the challenge in enlarging access to justice through recognition of public interest litigation. And PIL was born. The concept of PIL started in the USA, where it was seen as any litigation, that is, any legal case for protecting an individual rights, for minorities issues, and cases like discrimination against the employment, uh, abuse, or any sexual harassment, group rights like indigenous people's customary rights, and any case for the good of the general public. So it covers litigation in criminal and civil courts, rental courts, and class action for public good. The concept of PIL in India is borrowed from American law, and in the beginning, as we shall see later in detail, its purpose was to increase access to justice for the poor and disadvantaged. However, in India, public interest litigation petition is filed in the same manner as a writ petition is filed in the High Court and Supreme Court, and not in other lower courts. The definition of PIL. Public interest litigation is not defined in any statute or in any act. The expression public interest litigation has been borrowed from American jurisprudence, and it means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class or a community have pecuniary interest, or some interest by which their legal rights or liabilities are affected. This is taken from Black's Law Dictionary. In Janata Dal versus H.S. Chowdhury, 1992, the Supreme Court of India attempted to define PIL as follows. The expression litigation means a legal action, including all proceedings therein, initiated in a court of law for the enforcement of right or seeking a remedy. Therefore, lexically, the expression PIL means the legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. So, if you can see, the Black's Law Dictionary's definition has been incorporated. Over time, its nature changed. It covered a wide area of subjects from prisoners' rights, housing rights, protection of both accused and victims in criminal law, environmental rights, sexual rights, fundamental freedoms like mobility and travel, information, privacy, etc. It remained a writ petition, but it became an important legal and democratic tool, and the courts, as the third level of governance after the executive and legislature, rose to the challenge. So PIL at the root, taking the bull by the horns, is a remedy. So what is PIL? Basically, it means a case filed before the High Court or Supreme Court to protect or enforce an individual's right or group rights that have a public interest component. Even the individual right has to have a public interest component. Public interest means the good of the public at large, or rights that can affect a large number of members of the public. Basically, PIL was crafted by Indian judges into a unique remedy that afforded access to the poor, the disadvantaged, and minorities, as they called it. It was not really written in the law. The concept of PIL was judge-made. So it is our Indian system of common law in action, that is, judge-made law and rules handed down over the course of several judgments until finally the Supreme Court made special rules for PIL. It was judge-made and crafted and honed over time until it became a potent and empowering democratic tool, especially made in India for Indians by Indians. Why do I say this? Because in trying to increase the access of justice for the poor, the Supreme Court had to break a number of legal procedural rules and relax a number of hitherto dearly held legal concepts. We shall see more of this in future videos. So we can say that PIL grew organically, each time rising to some legal challenge, be it format or jurisdiction or procedural hurdle, or even in crafting appropriate remedies or separation of powers between the different arms of governance, that is the executive, the judiciary, and the legislature. It was not built in a single judgment, though each judgment strengthened the jurisprudence around the legal entity of PIL even further. Legal entity meaning the legal jurisprudence, the legal thing that was PIL. Hence, it was that the practical realization of the concept symbiotically helped reaffirm the concept, a kind of ring of eternity or the infinity symbol. Praxis in action. In the Constitution of India, several basic rights are guaranteed to residents or citizens of India. These fundamental rights are the rights that ensure an individual's equality in every aspect, irrespective of race, color, caste, religion, birthplace, or gender. These rights are mentioned under Articles 12 to 35 of the Indian Constitution in Part 3. However, without remedies, rights are mere ideals, promises, or pronouncements that may or may not be followed. As Justice Holmes said in Ex parte United States, legal obligations that exist but cannot be enforced are ghosts that are seen in the law but are elusive to the grasp. How are you going to ensure that rights are realized by the public and individuals? You need a remedy. So to protect rights, if you need a remedy, then to ensure that protection, you need the remedy to be recognized as a right. Has the right to remedy been recognized in India? The answer is yes, both in international law and in our constitution. Since India has signed a number of treaties and the right to remedy is found in international customary law and we are bound by it, so the international law also has become part of our law. So we will be examining the right to remedy under international law in the next video. Setting standards. PIL is a remedy specially formulated by the Indian judiciary. The Constitution of India recognizes the right to remedy. The concept of a remedy, types of remedies for violation of human rights, and the purpose of remedies have been formulated by international jurists and humanitarian law professionals. Hence, we will need to examine the concept of remedy in international law to understand the full scope of a remedy and all the different aspects of the right to a remedy, its purpose, effect, and what it contains, to see whether PIL is really an effective remedy. That is the standard that we'll be setting PIL against. So basically, we will be measuring PIL against the standard of an effective remedy to see how it measures up. Then we will go in depth into the right to remedy under our municipal, that is our domestic law under the Constitution of India. This will help us understand when we examine 50 years of PIL in action, the developments, the case law and the results, how far PIL is an effective remedy. So in summary, PIL is a remedy. The concept is borrowed from American law but is completely transformed to suit Indian conditions. It is filed as a writ petition. The judges of the Supreme Court and the High Courts have molded the remedy over 50 years to provide a range of recognitions and reliefs and have relaxed several legal rules and concepts in doing so. There are international standards of an effective right to a remedy. There is also a constitutional right to remedy in the Constitution of India that is a fundamental right. I will see you in the next video on the international law on a right to remedy. Until then, keep looking out for our videos. Remember, this is only the first in a long list of videos on PIL, and press that bell icon, like and subscribe. And if you can, also please like and subscribe to my other channel, K Priya Vasudevan. And buy my book Middle Time on Flipkart or Amazon if you want to.